So we're going to get to a complicated issue this morning, which ties into the Jackie Vautour case. We're going to be quoting from an article in the nationalobserver.com from 4 years ago, talking about what we say is unceded land. Now, Jackie Vautour and his family and many other families in Kouchibouguac Park had their land expropriated with a monetary compensation as the last step on territory that was never part of the Crown or never was discussed with the Crown. Basically, no treaties exist between the Mi'kmaq and Acadian Metis people in that part of New Brunswick with the federal Crown, or as one of our representatives in the protest, the corporation. Now, according to this National Observer article, what we mean when we say indigenous land is unceded. Again, by Emma McIntosh, January 24th, 2020. You might be living on unceded land, says the article. To be more precise, the Maritimes, near the Law of BC, and a large swath of eastern Ontario and Quebec, which includes Ottawa, sit on territories that were never signed away by the indigenous people who inhabited them before Europeans settled in North America. In other words, this land was stolen. It's worth noting that territories covered by treaties are also weren't necessarily ceded. In many cases, the intent of the agreement was a sharing of territory, not the relinquishing of rights. Now, Jackie has claimed Acadian Metis status, which is non-carded status in Aboriginal language, and majority of the people in New Brunswick that are non-status are Acadian Metis because they married in Acadian families, or let's say from the late 1700s, early 1800s, the established communities involving mixed blood or Acadian Metis blood with ancestors from the different First Nations. Mariah, Pabineau, Ilver Bar, Listugush, the different First Nations in the south, especially Kouchibouguac area. There was a crossover between the First Nation and the Acadian. They had many families. They harvested the land, be it fishing or farming or whatever. But the expropriation in 1969 is now considered illegal, and basically went on unceded territory and tried to negotiate with them where the land belonged to everybody. But they just stole it. Like I said, that was land that was not part of any treaty. Now, according to the article, what to do about it, however, is deeply complex, and legal questions about how to handle claims to unceded land have become a subject of public discussion as members of the Wet'suwet'en Nation in northern British Columbia have reoccupied their territory and attempted to block the coastal GasLink pipeline. Similar cases over Indigenous land titles are moving through courts across Canada. Now, Canada's Constitution is clear that Indigenous land rights exist, said Benjamin Ralston, a lecturer and researcher at the Indigenous Law Centre at the University of Saskatchewan. But in practice, fights over exactly what those rights are can take decades to resolve in court or in treaty negotiations, revealing cognitive dissonance in the system. The real problem is, what do we do about it now while these slow processes are proceeding, he said. In the case of this First Nation and Coastal GasLink, at issue is a divide between the traditional legal Wet'suwet'en legal system, Canada's legal system, those who have stood to protect the land in question, and those who want to see the pipeline built. Under Wet'suwet'en law, I can barely say it, I apologize, authority over the nation's 22,000 square kilometers of unceded territory lies with the hereditary chiefs from 5 clans who oppose the pipeline. However, there are also 5 elected band councils created by Canada's Colonial Indian Act, and some of the councils have supported the project. Now, a 1997 Supreme Court of Canada decision affirmed that the provincial government can extinguish their rights to their land. However, the court also sent the case back from a second trial that hasn't yet happened, leaving key questions unresolved. Now, last year, the RCP violently arrested Wet'suwet'en people and supporters in disputed area, with the Guardian reported late last year that police had been prepared to use lethal force. Earlier this month, the RCP set up a checkpoint to control access to the area after a BC Supreme Court judge extended an injunction to force out the First Nation members in the camps and allow construction on the pipeline to continue. Now, we are not trespassing. Takaya Blaney, one of several Victoria, BC activists, arrested and released after protests supporting it, said in a video posted on Facebook. Coastal Gas Link is trespassing. These cops are trespassing. They have no jurisdiction to violate Indigenous peoples and Indigenous youth on stolen land. The Wet'suwet'en are far from the only ones asserting their title to their traditional lands. In Nova Scotia, Mi'kmaq people have pushed for recognition of their unceded territory, and of course the Jackie Vautour situation with the Acadian Metis in what is now Kouchibouguac. In Ottawa, several Algonquin groups claimed the land at Parliament Hill and the Supreme Court of Canada sit on as theirs. And in 2014, Kouchibouguac Nation in BC became the first approved title or land in court. In 2017, about 140 Indigenous groups who had never signed treaties were negotiating with Canada's federal government, the New York Times reported. Now, several court cases have reaffirmed that the Canadian government has a duty to consult Indigenous people in cases that will impact their rights, which is meant to be an extra protection while land title cases get resolved. But that protection is imperfect. Duty to consult is not necessarily going to give you the full benefit of stopping a project. Now, in general, courts have also been reluctant to allow Indigenous land claims as a reason to block injunctions. Now, BC currently is the first Canadian jurisdiction to implement UNDRIP, the document that was passed by the UN General Assembly in 2007 over Canada's objections, and the country has so far been reluctant to formally implement it. It's not clear how the document could play in further disputes. Now, the unceded territory in Kouchibouguac, it gets complicated because you have full status in that region, okay, which is determined by the Crown, and you have people that are non-status who identify as Aboriginal, but it's not full what they call the status Indians. So you have non-status and status Indians. And of course, with that region, the 13 families or the key families that everybody recognizes as the lineage of the Vautour and other families. Now, you got to understand, unceded territory is a very complex thing because you can still be unceded territory and you could battle for recognition. This has been going on for decades. Like unceded, like in New Brunswick, Mi'kmaq, Maliseet communities. Basically, this is land that has been ancestral for years. Like there's First Nations in the province, but when it comes down to it, there's more off-reserve natives than there are natives in that area, but it's still unceded territory. So it gets very complex. Who claims unceded territory? The Aboriginal people and non-status, because the non-status, there's more of a population than the status Indians in New Brunswick. For example, in North Shore, there's 15 to 20,000 people with Aboriginal ancestry. Do in fact that my extended family, the LaPointes, are married or were spouses to people that were in Benjamin River and Hearn Island, who later went to Eelwer Bar to establish the First Nation there. So it gets very complex in every means or shape or means. Now, the reason why we're bringing this up is that a lot of reports with the Sacred Fire of Kouchibouguac, members of the Vautour family have been keeping that going for 100 plus days. They reestablished the encampment that was bulldozed in 2023. Now, that is ongoing. Certain members of the family who've been keeping the fire going were served with charges in July. They're appearing in court very soon. So we're going to keep you updated on that. But unceded territory is a very complex thing. Who determines what's unceded? Okay? It's not like the non-status Indians had like a council, organized council, like a First Nation chief and council. Basically, the people who were kicked off the land, the majority of people who were kicked off the land to make the park, were non-status Indians. But they're still on unceded territory. So it gets very complex. I'm not a lawyer, but if we had a lawyer, he could give you a 7-hour breakdown of what that means. But as it stands right now, it could be monetary compensation. It could be compensation to basically get back the lands that were taken, or it could be a combination of both. Like I said, it's an ongoing thing. So, ladies and gentlemen, that's a little story about the theory of unceded territory in New Brunswick, BC, other parts of Canada. Again, very complex. And there's only a few experts across Canada that can really talk at length about the unceded territory, New Brunswick, because we hear the bigger centers and stuff, but New Brunswick is, like I said, very complex because there's Métis across Canada, but they're not like us. Our Métis is a mix. Some goes back to the 1600s through Quebec. Some goes back to the 1800s, like Northern New Brunswick. Jackie Vautour family, 1700s and 1800s. Like I said, you're talking non-status Indians have been staying on unceded territory, since, 16-something, because a lot of them cross over, so. Anyway, ladies and gentlemen, this is dedicated again to the Vautour family. If you like what they're doing here with our information podcast, let us know with a like, comment, subscribe, or share. Bye.